I've watched a lot of strangers walk through my courtroom doors over the years, but nothing, and I mean nothing, prepared me for the morning Caroline Whitfield Ashcroft walked in. She walked in like she owned the room, designer sunglasses still on her face inside the building, a leather purse swinging from her wrist that probably cost more than the bailiff's monthly take-home. She didn't look at the clerk. She didn't look at the bailiff. She didn't even glance at the prosecutor's table. She just walked to her seat like she was walking into a country club lounge, and she sat down and she sighed. Loud, like the rest of us were inconveniencing her by existing. And here's the thing. What she didn't know, what she couldn't have possibly known when she walked through those doors that Tuesday morning, was that the judge she was about to sigh at, the judge in the black robe at the top of that bench, was a little girl named Patty from a row house on Linden Street in Pittsburgh. And 48 years ago, that little girl and a little girl named Caroline Whitfield had been the closest thing to sisters either of them ever had. In my courtroom, your last name doesn't grant you immunity. Your bank account doesn't grant you immunity. And as I learned that morning, neither does our history. What happened in the next 45 minutes became the kind of story that gets passed around the courthouse for years, the kind that landed on the national news cycle within 72 hours, and the kind that I've been carrying with me ever since. Let me back up a second. Caroline arrived 22 minutes late. Not fashionably late, disrespectfully late. The kind of late that tells everyone in the room that their time is worth less than yours. She came in with a custom-tailored cream blazer over a black silk blouse, slacks pressed to a knife's edge, and heels, black Louboutins, the red soles flashing every time she took a step, a Cartier love bracelet on one wrist. A watch on the other that I later learned retails at around $44,000. And those sunglasses, oversized, black. Still on her face when she sat down at the defendant's table. Her attorney was already there, a man named Whitman from one of those firms with 4 last names on the door. Gray suit, navy tie, the kind of leather document case carried by an aide who scurried in behind him. Whitman had represented her family for 2 decades, her family being the Ashcrofts. Her late husband, Richard Ashcroft, had built a real estate empire across 3 states before he passed, and Caroline inherited an estimated $1.8 billion in assets, which she has spent the last 6 years managing badly and spending well. She had a habit, by the way, of treating courtrooms like inconveniences. This wasn't her first appearance. It was her 4th in 18 months. Reckless driving, a noise ordinance violation that involved her hosting a 100-person party at her summer home in violation of local code, a civil suit from a former housekeeper that was settled quietly. And now this is what brought her to my bench. The bailiff asked her politely to remove the sunglasses. She did eventually, after he asked twice. She set them on the table with the care of someone setting down a wine glass at a charity gala. And when she finally looked up, when her eyes adjusted to the courtroom lighting and she scanned the bench, that's when I saw it. The flicker, the half-second hesitation, the face that almost recognized me and then immediately decided it couldn't possibly be true. Because in Caroline Ashcroft's world, the people from Linden Street in Pittsburgh do not end up wearing black robes. They stay where they belong. Now, let me tell you about the victim. His name was Earl Hendricks, 61 years old. A maintenance supervisor at the Ashcroft estate for 19 years. Earl came into my courtroom that morning wearing the cleanest shirt he owned, a light blue button-down with a small darn near the collar that someone had stitched back together, probably his wife of 36 years, a woman named Doreen, who taught 2nd grade in the same elementary school for 28 of those years before retiring. Earl was a Navy man, served 4 years in his 20s. Came home, married Doreen, took a maintenance job, raised 2 children, put both of them through state schools, and never asked for a thing from anybody. Earl carried a small brown paper bag into the courtroom with him. He set it on the table beside him and folded his hands over it like it was a Bible. I noticed it right away. You learn to notice things like that after a few decades on the bench. A man comes into a courtroom carrying a paper bag. That's not a coincidence. That bag has a meaning, and we'll get to what was in it, but not yet. Hold on to the paper bag. It's going to matter more than anyone in that room realized. Earl had a cast on his left wrist, a clean white cast signed by what I assumed were grandchildren in colored marker. 3 small signatures, hearts, a little drawing of a stick-figured dog. The cast went from his knuckles to halfway up his forearm. The complaint indicated that the fracture had required 2 pins, that he was looking at 6 to 8 months of physical therapy, and that he would likely never have full range of motion in that wrist again. which, for a maintenance supervisor whose entire livelihood depended on using his hands, was the end of his career as he knew it. The charge against Caroline Ashcroft was misdemeanor assault and willful destruction of property. According to the complaint, Earl had approached Mrs. Ashcroft in the driveway of her estate on a Tuesday afternoon in March to inform her that the gate sensor she had asked him to repair was now functioning. Mrs. Ashcroft, who had been waiting for a private car to take her to the airport, had become irritated that Earl was standing near her vehicle and, when Earl tried to step back, had, and I'm quoting from the police report here, struck the complainant on the wrist with a metal-bodied designer handbag and pushed him backward into a stone planter where the complainant fell and sustained the injury described. Earl had not pressed charges immediately. He'd gone home that night, had Doreen drive him to the urgent care, gotten the cast put on, and had decided, in his words, that he was going to let it go. Doreen, as Doreen later told me herself, did not let it go. She called the police the next morning, and here we were. Caroline Ashcroft, when the charge was read aloud, rolled her eyes. I watched her do it. The bailiff watched her do it. The court reporter watched her do it. Earl Hendricks did not watch her do it because Earl Hendricks was staring straight ahead at the wall with the kind of dignity that working-class people summon when they know they're being disrespected, and they refuse to give the disrespecter the satisfaction of a reaction. I'll be honest with you. The eye roll alone would have earned a warning in my courtroom, but I let it pass. I wanted to see how far she'd go. She went further. Her attorney, Whitman, began to argue that this was a misunderstanding, that Mr. Hendricks had been an exemplary employee for almost 2 decades, that Mrs. Ashcroft had no intention of causing harm, and that the family was prepared to make a generous offer to settle the matter outside of court. As he was speaking, and I want you to picture this, Caroline pulled out her phone in my courtroom while her attorney was speaking on her behalf. And she started scrolling. I gave it 20 seconds. Strategic silence works wonders on people who think they're in control. 20 seconds is a long time in a quiet courtroom. The court reporter looked up. The bailiff shifted his weight. Whitman, mid-sentence, trailed off because he could feel something happening behind him. And Caroline, who was watching some video on her phone with the volume low, but not low enough, I could hear the tinny audio of someone laughing, finally looked up. She made eye contact with me. She did not put the phone down. Mrs. Ashcroft, I said, is there something on your phone that's more important than these proceedings? She tilted her head, looked at me the way you look at a waiter who's brought you the wrong order. And she said, and I'm quoting her here, the court reporter has it on the record, she said, honestly, Your Honor, probably. The gallery gasped, audibly. I heard a woman in the second row say, oh my God, under her breath. Whitman put his head in his hands, literally put his head in his hands. I saw a junior associate at the prosecutor's table cover his mouth to keep from laughing. And me? I just looked at her. I've been doing this long enough that certain looks carry weight. I let the silence sit for another 10 seconds. Then I said very quietly, put the phone in your bag, Mrs. Ashcroft. If I see it again today, you will spend the night in a holding cell. Do you understand me? She rolled her eyes again. She put the phone in her bag. She said, whatever you say, Your Honor. Now, look. I want to pause here for just a second because I'm going to be honest with you. The part of this story that still gets to me, the part that made me set my reading glasses down on the bench and stare at a wall for a full minute before continuing, I'm saving that for a few minutes from now. Because if I tell you now, it doesn't land the same way. Just trust me. Stay with me. There was one more person in that courtroom that morning, sitting in the third row, who I haven't told you about yet. A woman, 62 years old, gray hair pulled back, wearing a teal cardigan that looked like she'd had it for 15 years. I'll get to her. Her name was Doreen Hendricks, Earl's wife. And she had brought something into the courtroom, too, in her handbag that I would not learn about until after the verdict was read. The prosecutor moved to introduce the security footage. I granted it. The bailiff dimmed the lights. The monitor came down from the ceiling. And what we watched, the 11 of us in that courtroom and the half-dozen others in the gallery, was 47 seconds of video from a security camera mounted on a lamppost at the edge of the Ashcroft estate driveway. The footage was crystal clear, color, high definition. Audio captured by a directional mic the security company had installed 2 years prior. We watched Earl Hendricks walk up to the driver's side of a black Mercedes Maybach, where Caroline Ashcroft was already seated in the passenger seat with the door open, talking to her private driver. We watched Earl say something, and in the audio caught it perfectly. Mrs. Ashcroft, ma'am, just wanted to let you know the gate sensor is fixed. You're all set. We watched her turn. We watched her face. We watched her say clearly, audibly on the record, I don't pay you to talk to me, Earl. I pay you to fix things and disappear. Then we watched her stand up out of the car. We watched her step toward him. We watched Earl take a step back, hands raised in a non-threatening gesture, the universal posture of a man who has worked for difficult people for 40 years and knows how to de-escalate. And we watched Caroline Ashcroft swing her metal-bodied designer handbag in a clear, deliberate arc and strike him on the wrist. Hard. The audio caught the impact. A flat, sharp crack. Earl stumbled backward. He fell into the stone planter. He landed on his side with his left arm pinned beneath him. And Caroline Ashcroft, on the video, on the record, looked down at him and said, and I want every single one of you to hear this, get up. You're embarrassing yourself. The courtroom was silent. 47 seconds, and you could have heard a pin drop. When the footage ended and the lights came back up, I looked at Caroline Ashcroft. And what I saw on her face was not shame. It was not recognition. It was not the dawning awareness of a person who had just watched themselves do something terrible in a public setting. It was annoyance. It was the face of a woman who was annoyed that we were all making such a big deal out of this. I've learned to recognize that look. It's the sound of assumptions crumbling in slow motion on someone who doesn't yet know their assumptions are about to crumble. I asked her very calmly if she had anything she wanted to say about the footage. She looked at her attorney. He shook his head almost imperceptibly. She looked back at me, and she said, "Look, Your Honor, the man works for me. He was in my way. I had a flight to catch. I didn't mean to actually hurt him. I mean, my purse is heavy. That's not my fault." "Your purse is heavy," I repeated. "Yes, Mrs. Ashcroft, your purse is heavy because you chose to buy a purse that weighs 4 pounds and has metal reinforcements at the base. That's not an accident. That's a choice. I didn't pick it for that reason." "What reason did you pick it for?" She paused. She actually paused. And then she said, "Because it's a good bag." Folks, I want you to understand something. I have sat on this bench for 26 years. I have heard every excuse human beings can invent. I have heard people blame their childhoods, their medications, their ex-spouses, their parents, the weather, the moon, and once, I'm not making this up, the influence of a podcast they'd listened to that morning. I have heard it all. And in 26 years, I have never heard a defendant justify breaking a man's wrist on the basis that her handbag was a good bag. I let her sit with it. I let her sit with what she just said. Strategic silence works wonders. Whitman tried to intervene. He said, "Your Honor, my client is under significant emotional strain," and I raised one hand. Just one hand. He stopped talking. He stopped talking because he could feel what was coming, the way you can feel a thunderstorm in the back of your neck before the first drop hits. I picked up the victim impact statement that Earl Hendricks had written by hand in pencil on lined notebook paper and submitted to the court the night before. I had read it that morning in my chambers. I'd read it twice. And now I was going to read it aloud. "My name is Earl Hendricks," I began. "I worked for the Ashcroft family for 19 years. Mr. Ashcroft, before he passed, was a good man to me. He came to my daughter's wedding. He helped pay for my son's college when my insurance didn't cover something. I owe that family a lot, and that is why I tried to let this go. But my wife asked me to come here today, and I owe my wife more than I owe anybody." I paused. The room was completely still. I'm a maintenance worker. I fix things. I have fixed things my whole life. My hands are how I provide for my family. The doctor told me last week that I may never get full strength back in my left wrist. I am 61 years old. I do not know what I am going to do. Mrs. Ashcroft, when she hit me, she did not just break my wrist. She broke the agreement that I thought we had, which was that if I worked hard and showed up every day and did my job, I would be treated with basic respect. I am not asking for money. I am asking for the court to make her understand that what she did was not acceptable. That is all. Thank you for your time. Earl Hendricks. When I finished reading, I looked up. Caroline Ashcroft's hands were trembling. I watched them. They were trembling slightly, the way hands tremble when a person realizes for the first time that they may have miscalculated. Her face had gone pale. The Cartier bracelet on her wrist caught the courtroom light, and she looked down at it like she was seeing it for the first time. I stood up. The courtroom leaned forward. "Caroline Whitfield Ashcroft," I said, and her head came up sharply at the use of her maiden name, because she hadn't gone by Whitfield in over 30 years. "On the charge of misdemeanor assault, this court finds you guilty. On the charge of willful destruction of property, Related to the cost of Mr. Hendricks's medical equipment and lost wages, this court finds you guilty. She opened her mouth. I held up a hand. She closed it. You will serve 60 days in county jail. Not work release. Not house arrest. Not a deferred sentence. 60 days actual incarceration beginning today. Your driver's license is suspended for 1 year. You will pay restitution to Mr. Hendricks in the amount of $47,200, which covers his immediate medical bills, his projected physical therapy, and 2 years of lost wages at his current salary. You will complete 400 hours of community service at the Veterans Memorial Hospital in Beaver County, where you will be assigned to the orderly staff. You will scrub floors. You will change linens. You will work alongside the kind of people you have spent your life believing were beneath you. And you will write Mr. Hendricks a letter of apology in your own handwriting, which will be reviewed by this court for authenticity before it is delivered. The courtroom was silent. Whitman was staring at the table. Caroline Ashcroft was staring at me. And then I said the thing I had not planned to say, the thing I had told myself on the drive-in that morning that I would not say. Caroline, I said, do you remember Linden Street? Her face changed, slowly, like a Polaroid developing. Patty? She whispered. I nodded once. We were 8 years old, I said. Your father lost his job at the steel mill. My mother gave your family groceries for 6 months. You slept on the trundle bed in my room 3 nights a week for an entire winter because your mother was working a night shift and your father was looking for work. We were children, and we had nothing, and we shared everything. And I have been watching you for 30 years become a person that the 8-year-old girl I knew would not recognize. I cannot fix that. The law cannot fix that. But the law can ask you to spend the next 60 days and the next 400 hours in the company of the kind of people you used to be. I hope you find her. I hope you find the little girl from Linden Street, because she's still in there somewhere and she deserves to come home. Caroline Ashcroft started to cry. Not performative tears, real ones, the kind that come from somewhere a person has spent decades trying to wall off. In the back of the room, Doreen Hendricks stood up. She walked slowly to the front of the gallery, and she reached into her handbag and she pulled out something I had not expected to see. A photograph, old, black and white, curling at the edges. She handed it to the bailiff, who walked it up to me. The photograph showed 2 little girls, maybe 7 years old, sitting on the front steps of a row house, arms around each other, both grinning. One of them was me. The other was Caroline. Earl found it, Doreen said quietly, in a box at the estate. He didn't know who it was, but he kept it because he thought one of them looked like you, Judge. I looked at the photograph for a long moment. Then I looked at Earl. Earl Hendricks, sitting at the plaintiff's table with his hand on a brown paper bag, looking at me with the kind of steady, knowing expression that working people have when they understand a situation more deeply than anyone else in the room. The brown paper bag. Right. I told you we'd get back to it. Earl opened the bag slowly and pulled out what was inside. It was a small framed Navy commendation from 1983. His honorable discharge papers, and underneath those a handwritten note. Earl handed all of it to the bailiff, who brought it to me. The note was from Earl. It said, Judge, my wife told me you might be the same Patty Sullivan that grew up on Linden Street. My uncle Frank Hendricks lived on that street too. He used to talk about your mother. Said she was the kindest woman on the block. I wanted you to know I'm not asking for anything special. I just wanted you to know I see you. Sincerely, Earl? I set the note down on the bench. I took off my glasses. I looked at Earl. And for the first time in 26 years on this bench, I said very quietly, thank you, sir. The bailiff led Caroline Ashcroft out of the courtroom. Her Louboutins clicked against the tile floor on the way to the holding area. Her attorney followed, head down. The gallery was silent. Now, here's what happened next. 6 months later, I got a letter, handwritten, from the Veterans Memorial Hospital in Beaver County. It was from Caroline. She had finished her 60 days. She had served them quietly, no special treatment, no requests for transfer. She had begun her community service at the hospital. She had been assigned to the orderly staff, just as I'd ordered. And she had been, in her words, the worst orderly the hospital had ever seen for the first 3 weeks. She didn't know how to mop a floor. She didn't know how to change a hospital bed. She had cried, she wrote, in the supply closet on her second day for 40 minutes because a Vietnam veteran named Mr. Cardoza had called her ma'am and thanked her for bringing him a cup of water. She wrote that something had shifted. She didn't know exactly when. She had started staying late. She had started learning the patients' names. She had asked the hospital if she could continue volunteering after her 400 hours were complete. They had said yes. She also wrote that she had sent Earl Hendricks a check separate from the restitution in the amount of $80,000 to be used however he and Doreen saw fit. Earl, being Earl, had used $12,000 of it to fix his truck and pay off the last of their mortgage. The rest he had donated to the maintenance staff scholarship fund at the local community college in his late mother's name. A year after the trial, the local newspaper picked up the story. Then a national outlet, then a morning show. The Veterans Memorial Hospital reported that volunteer applications had increased by 412% in the year following the case. The Community College Scholarship Fund, funded entirely by Earl's contribution, had put 19 first-generation college students through their first 2 years of school. And the Pennsylvania state legislature, citing the case directly, had passed an amendment to the workplace assault statute that increased mandatory minimums for assaults committed by employers against employees. Earl Hendricks is now 63. His wrist healed mostly. He never went back to full-time maintenance work. The strength didn't fully return, but he now runs a mentorship program at the community college, teaching young men trade skills. Doreen still teaches Sunday school. They have 4 grandchildren now. Caroline Whitfield Ashcroft sold her estate. She sold the cars. She sold the jewelry. She moved into a 2-bedroom apartment near the hospital and now serves as the director of patient services. She earns $68,000 a year, which she has told me is the most honest money she has ever made. She and I have lunch every few months. We don't talk about the case. We talk about Linden Street, about her mother who passed away years ago, about my mother who passed last spring, about the girls we used to be before everything else got in the way. And the photograph that Earl found in that box at her estate, the one of the 2 of us as little girls on the front steps, Caroline framed it. It sits on the desk in her office at the hospital. She told me the last time we had lunch that she looks at it every morning before she starts her rounds. That's what justice looks like when it's working correctly. Not the punishment alone, not the sentence alone, but the door we leave open just a crack for the person who's done wrong to walk back through and become who they were supposed to be. Accountability isn't cruelty. It's the greatest gift we can give a person who has lost their way. The law is not in the business of revenge. The law is in the business of returning people to themselves. And sometimes, if you're very lucky, it returns 2 old friends to each other after a lifetime apart. That's the story I've been carrying. That's why I told it. And that's all I've got for you today.